Welcome to the 2016 spring meeting of the American Bankruptcy Institute. I am Bill Rochelle, ABI's editor-at-large. Sitting with me is the Honorable Gregg Zive, United States bankruptcy judge from Reno, Nevada, since 1995, is that right?
That's correct.
Well, it's a mighty long time.
It is.
And I might say, from my own personal observation, Judge Zive, folks have gone out of their way over the years to file Chapter 11 petitions in your neck of the woods in Nevada so they can be sure of having you as a judge in a major reorganization. So congratulations.
Well, thank you.
Now, I gather you went to Notre Dame Law School, is that right?
I did.
How come you picked Notre Dame?
Well, my undergraduate degree is in journalism. I worked as a sports writer while I was an undergraduate. And then when I spent 2 years on active duty as an officer in the Army, and I published a newspaper at Fort Ord. And then I was a reporter for a short period of time for the Monterey paper, sports editor of the Salinas paper. I decided if I was going to go to law school, and it was as boring as I thought it might be, I wanted to see some good football and basketball. And I saw some of that at Notre Dame. And I worked for the sports information director all 3 years there, so it worked out very nicely.
Well, that was a very good decision on your part.
Oh, I thought so. It's a great school.
Folks in Nevada are lucky that you've been a judge there for, what, 21 years?
21 years. I wouldn't put that up to a vote, but I'm happy to have been there.
Well, Nevada was a district in which there was, I'd say horrendous conditions for consumers and bankrupts as a result of the terrible housing crisis you had in Nevada. You had an onslaught of consumer bankruptcy filings and similar things. How are things in Nevada these days?
Well, they've improved considerably. We had the highest foreclosure rate in the United States for 4 years or longer. We had the highest unemployment rate in the United States for years. There were entire neighborhoods that were decimated, particularly in Las Vegas. Reno was also dramatically affected by the downturn in housing. The filing rates have dropped considerably. When I retired and went recalled at the end of 2010, 2011, our weighted caseload per judge was enough for 12 judges.
How many?
12.
12.
And we had 4. And one of the reasons that I retired is that a new judge was appointed to take my position. I went recalled, so effectively we got 2 judges. And that was necessary. Now our caseload is down. Our hours and cases per judge are greatly reduced. And I think it's evidence that our economy has come back. It is growing, and there are still serious issues that have to be considered, but I think it's far better than it was.
Let me ask you a question about mediation, because it has dawned on me that I have seen your name come up many, many more times than most judges to serve as mediator in important cases. How come that's happened?
Well, I'm not quite sure. I enjoy doing that type of work, and we've had some success. And then in certain areas where you get the same type of cases, the judges of the parties want to get a judge who has some expertise. It saves time, it saves money, and allows you to get involved.
To what type of cases are you referring?
Well, I'm doing a number of the Catholic filings where sex abuse has driven the filings. I was the settlement judge in the Spokane Diocese in the Portland Jesuit case. I'm now doing it in the Stockton Diocese, and I've been appointed to do it in the Duluth case as well. Candidly, it's hard work. There's a lot of legal issues and insurance issues. There's the overriding concern for the acts themselves and the people who are the victims of those acts. They're very challenging. And I never thought, candidly, even as long ago as 5 years ago, I would have a subspecialty in sex abuse cases. But I seem to have that, and that's why I think you get selected. People find out that you have handled these and have built up some experience, and so they'd rather than educating somebody new, they can use an experienced person. And I've done the San Bernardino municipal case. And that was new for me, but there's a small number of judges who have been involved in those cases, and I've been able to communicate with them pick their brains and learn how they approached it. So it's been quite an experience.
You know, Judge Zive, the bankruptcy courts really, among all of the courts in this country, have been at the forefront of mediation, beginning a few years ago, really, to heavily rely on mediators to try to bring solution to very complicated, seemingly intractable Chapter 11 cases. In your experience as serving as a mediator, do you think that there is room for either legislation or rulemaking to better codify the mediation process around the country?
Well, yes. Short answer is yes. But you have to be aware, I think, that there are two types of mediators. There's the private mediators that are getting paid. And a lot of districts have local rules that already provide how the mediators are going to be selected, how they're going to conduct themselves, what pay they're going to get. And then there are private mediators that do it for a living, as just being appointed by a court. And parties go to them independently, sometimes without a court order, just to have them mediate cases, like JAMS and Judicare West and others that do the same type of thing. Then there are the judicial mediators, which is what I do, of course. And judicial officers really aren't mediators, we're settlement judges, but we do not function as judges in that type of capacity as a settlement judge. We don't make decisions, we don't render opinions, and it's important for the parties to understand that, and for the judicial officer to understand that's not our role. We facilitate conversation. And I think for judges that have been involved in Chapter 11 work, that it's natural, because Chapter 11 should be a negotiated result that ends up in a plan, generally a consensual plan. Sometimes you need to cram down. But that negotiation that leads to a consensual plan is the same type of skills that are used in mediation.
Yep.
So they tend to follow each other.
Are there areas, though, where, based upon the experience of people like you who've done it very heavily, that there really should be codification and rules to make the process and standards more clear?
And as I said, though, there tend to be local rules, but there are model rules that have been promulgated and have been utilized in a number of districts. I have some from the ABA and from other sources. There's the Restatement Third that deals with the law governing lawyers, and it has addressed these issues as well. There are other publications. I was on a panel this morning that talked about mediation, and Dobbs particularly talked about ethics, and he listed a number of sources, and they're in the materials for this conference. And I think that any judge who wants to use mediation should take a look at those and see if they can be enacted or adopted in the local district. And I think mediators have to be familiar with those rules. I'd rather see it done by rulemaking rather than legislation, because it's easier to amend the rules if it becomes necessary to do so. If you find something's not working, then you can change them far more efficiently.
Well, that's words of advice from a man who has been around the block quite a few times in successful mediations, I might add, and it seems to me that's a very good idea to codify mediation rules so that we don't have common law basically in every district.
I didn't mean to speak over you, but there are so many considerations that most lawyers don't think about when they become mediators. There's ethical issues, there are compensation issues, there are confidentiality issues, there are potential conflicts they have to be aware of. So there's a number of considerations that I think sometimes are overlooked.
Well, let's hope it happens. Judge Zive, I thank you very much for your time, and be well.
Thank you very much. Appreciate it. That all right?